From a pig who shot an innocent unarmed man.
And now this is an Officer Villarreal's car. I hear him say, "Take your hand out of your pocket," and I hear the gunshot almost simultaneously.
To a disgraced cop who was found accusing innocent people of carrying drugs.
The drugs were there. I did not put the narcotics there.
Today, we will be going through some of the worst cops that were humiliated and disgraced in the courtroom. Starting off with Jackson County Deputy Zachary Wester, who was accused of planting drugs on innocent people. A total of 12 drivers reported that he had planted narcotics in their cars and then arrested them. Wester was ultimately charged with 67 counts in connection to his actions.
A substance that appears to be an illegal narcotic. Do you know anything about that?
I do not.
Have you ever seen this before?
No, what is that?
I'm just trying to figure out how that stuff got in your car. You're gonna go to jail today for possession of methamphetamine, okay?
Oh man, dude, I'm serious, dude. Anything, what you want me to do, man? And I knew my truck was clean. I knew it was.
Anything in the vehicle I need to be concerned about? Bombs, hand grenades, rocket launchers? Okay. Miss Odom.
It is yogurt, sir.
I know. Okay.
It's yogurt.
How about this, though?
That is not mine. No, sir.
Okay.
Now, the white small plastic baggie that was in that spoon that the deputy just showed you on this video, had you ever seen that before?
No, sir.
Was that in your car?
No, sir.
The drugs were there. I did not put the narcotics there.
After a lengthy trial that mostly involved the victims taking the stand against the corrupt officer, the jury reached its verdict and announced a lengthy punishment.
In the state of Florida versus Zachary Tyler Wester, case number 19-CF-431. We, the jury, find as follows as to the counts charged and the information. Count 1, guilty of racketeering as charged. Count 2, not guilty. Count 3, not guilty. Count 4, not guilty. Count 5, not guilty. Count 41, guilty of possession of controlled substance related to February 15, 2018, as charged. Count 42, not guilty. Count 43, not guilty. Count 44, guilty of possession of a controlled substance related to April 17, 2018, as charged. Count 65, guilty of false imprisonment related to Stephen Van, as charged. Count 66, not guilty. Count 67, not guilty.
All right, Mr. Clerk, if you'll go ahead and poll our jury. Ladies and gentlemen, I want to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in your jury room.
Deputy Wester was found guilty in 19 of the 67 charges he had on him. In the next hearing, the judge finally announced the much-awaited sentence for the corrupt cop.
All right, Mr. Wester, this court now sentences you as follows in this case. As to count 1, racketeering, which is a first-degree felony, you are sentenced to serve 5 years in the Florida Department of Corrections. As to count 7, official misconduct, that's a third-degree felony, you are sentenced to serve 18 months in the Florida Department of Corrections. That will be served concurrent with count 1, false imprisonment. That's a third-degree felony. You are sentenced to serve 1 year and 1 day in the Florida Department of Corrections, consecutive to count 64. Counts 7, 9, 10, 31, 33, 34, 41, 44, 48, 64, and 65 are to be served consecutive to each other for a total sentence in this case of 12 years, 6 months, and 8 days in the Florida Department of Corrections. This sentence of 12 years, 6 months, and 8 days in the Florida Department of Corrections is to run concurrent with a 5-year Department of Corrections sentence in count 1. Therefore, it is the intention of the court that you are sentenced to serve a total of 12 years, 6 months, and 8 days in the Florida Department of Corrections. I'm also going to award the defendant 58 days jail credit as to count 1 and count 7. As count 7,
he was eventually punished with 12 years in prison and was also fired from his position. Well, this next officer was convicted of an even worse crime and taken to the cleaners by the judge.
The court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000, and will require you to pay the court costs.
During a traffic stop in 2017, Euclid police officer Michael Amiot was seen repeatedly punching and kicking the victim, Richard Hubble. After this incident, he was charged with assault and interfering with civil rights. His trial commenced after a 2-year delay, and the jury eventually reached a verdict.
We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot not guilty of assault, a misdemeanor of the first degree in violation of Section 2903.13a of the Ohio Revised Code, as charged in count 1. We do so render our verdict this 29th day of July, signed by all 8 jurors. Verdict. We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot guilty of assault, a misdemeanor of the first degree, in violation of Section 2903.13a of the Ohio Revised Code, as charged in count 2. We do so render our verdict this 29th day of July, 2022, signed by all 8 jurors. Do hereby find the defendant Michael Amiot guilty of interfering with civil rights, a misdemeanor of the first degree, in violation of Section 2921.45a of the Ohio Revised Code, as charged in count 3. We do so render our verdict this 29th day of July, 2022.
After a lengthy trial that involved debates from both sides, the jury unanimously decided that Michael Amiot was guilty on both counts.
No second guessing. You've done your job. If someone else didn't, that's not your job. You've done it. With that, you will be discharged. If you'd like to hang around a few minutes and talk with me, I will do that. If you do not, that's entirely understandable. Sometimes the lawyers would like to talk with you to determine how they came across to you, but again, that is your decision as to whether you wish to speak with them. I want to thank everybody for their conduct. I know it got a little contentious at time, but that's to be expected sometimes. With that, we adjourn. Yes. Well, counsel, would you approach, please? I'm sure.
The former officer remained emotionless while listening to the verdict and just quickly made his way out of the courtroom. The very next day, the judge announced his sentence. But before that, the victim was allowed to have some words.
I appreciate the jury and the court for making the right decision. You know, what Amiot did to me was wrong. He should have received the maximum sentences today. You know, I'm still going through like the suffering with the anxiety, you know, driving, just the temperament, the trauma and everything, just a cause for this case. I'm ready to get it over it actually, but just coming back in here just like bring up everything, you know, and just to see him over there, you know, see all that just coming back in this court, just like it just brings up everything, like we live in the moment. So, you know, I hope he gets the maximum sentences today, Your Honor.
One of the things that stood out to me is that the initiation of this incident probably never should have occurred when you receive that initial radio communication. That initiated this whole thing. And the other thing that sort of stood out to me was that in approaching the vehicle and asking Mr. Hubbard to get out of the vehicle, from my perspective, there was an inability for him to get out of that vehicle without making contact with you. Inability to get out of that vehicle.
The judge, who was also an African American, expressed great discomfort at the officer's actions and went on to hold him accountable.
I believe the jury got it right. I do. And the court must impose the sentence that the court feels is appropriate in a case like this. And I appreciate the information provided in the pre-sentence investigation. And generally, I'm the type of person that generally follows recommendations, generally speaking. I'm not here today to send a if you need assistance, you need to go and get that assistance. But I'm not going to say you're not going to have instances of flashback or what have you, but you need to move on with your life also.
Oh, yeah, yes, for sure.
And not let this incident continue to hover over you. The city compensated you.
After giving some closure to the victim, the judge announced the verdict for Michael Amiot, who once again showed no emotions whatsoever.
Based upon the evidence presented and the pre-sentence investigation, the court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000, and will require you to pay the court costs. In addition, the court will suspend the sentence of 90 days, place you on non-reporting community control for a period of 1 year. If you violate during that 1 year, then the court will retain the ability to impose the sentence. Anything on behalf of the state?
No, Your Honor.
On behalf of Ms. Damiat?
Just what count is this court electing to submit?
However, given the length of time involved here, the court will use the assault as opposed to the violation of civil rights. Not saying they weren't violated, but given the length of time, the court will use the assault charge. Anything else?
No, thank you, Your Honor.
That's all. Good luck to you, sir.
Thank you.
The corrupt cop was only sentenced to 90 days in prison, which was also discarded eventually. However, he was rightfully fired from the police department and won't be terrorizing the streets again. Now, while this cop got away cheaply, the next judge made sure to hand out an exemplary sentence.
As sentence for count 1, the court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270.
In May 2020, police officer Derek Chauvin brutally murdered George Floyd after he was arrested for making a purchase with a counterfeit $20 bill. Chauvin was ultimately charged with second-degree murder and third-degree manslaughter.
I've read all the impact statements that were submitted earlier and listened carefully to all the input here today, and it is truly appreciated that you took the time to stay with this case and to provide me with input. I have reviewed the pre-sentence investigation and carefully considered all the facts of the case and the law, but my comments are actually going to be very brief because most of it's going to be in writing. I have a 22-page memorandum that is going to be attached to the sentencing order. And why am I doing it in writing? To emphasize the fact that determining the appropriate sentence in any case, and in this case, is a legal analysis. It's applying the rule of law to the facts of an individual and specific case. And that is why, as opposed to trying to being profound here on the record, I prefer that you read the legal analysis that explains how I determined the sentence in this case.
Apart from Derek Chauvin, 3 other officers were also charged for this incident as they assisted Chauvin in restraining him. Officer Thomas Lane went ahead and even pointed a gun at his head.
What the case is, or what the sentence is not based on, is emotion or sympathy. But at the same time, I want to acknowledge the deep and tremendous pain that all the families are feeling, especially the Floyd family. You have our sympathies. And I acknowledge and hear the pain that you are feeling throughout Hennepin County, throughout the state of Minnesota, and even the country. But most importantly, we need to recognize the pain of the Floyd family. I'm not going to attempt to be profound or clever because it's not the appropriate time. I'm not basing my sentence also on public opinion. I'm not basing it on any attempt to send any messages. A trial court judge, the job of a trial court judge is to apply the law to specific facts and to deal with individual cases.
This incident sparked worldwide protests and also kick-started the Black Lives Matter movement. The judge was also aware of this and knew that he had to announce an unbiased sentence, which set a precedent for police accountability in cases like these.
As to count 1, based on the verdict of the jury finding you guilty of unintentional second-degree murder while committing a felony under Minnesota Statute 609.19 subdivision 2 paren 1, it is the judgment of the court that you now stand convicted of that offense. Pursuant to Minnesota Statute section 60904, counts 2 and 3 will remain unadjudicated as they are lesser offenses of count 1. As sentenced for count 1, the court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270. That is a 10-year addition to the presumptive sentence of 150 months. This is based on your abuse of a position of trust and authority, and also the particular cruelty shown to George Floyd. You are granted credit for 199 days already served. Pay the mandatory surcharge of $78 to be paid from prison wages. You're prohibited from possessing firearms, ammunition, or explosives for the remainder of your life. Provide a DNA sample as required by law. Register as a predatory offender as required by law. And then you will receive a copy of the order and also the attached memorandum explaining the court's analysis.
If this needs to be said, we just ask that it be executed forthwith.
Defendant is remanded to the custody of the sheriff to be transported back to the DOC or whichever custody is currently holding him. Anything for the defense? All right. Thank you. We are adjourned.
Chauvin was sentenced to 22.5 years in prison. The other 3 officers were also found guilty and were sentenced to up to 4 years in prison. Justice was well and truly served, just like in this case, where an officer's lawyer continuously fights to evade his charges.
And now this is an Officer Villarreal's car. I hear him say, take your hand out of your pocket, and I hear the gunshot almost simultaneously.
In December of 2011, Tustin police officer Osvaldo Villarreal responded to a domestic dispute call, where he met the victim, Benny Herrera, whom he shot twice and killed on sight. Although he was cleared initially, later on in 2016, Herrera's family filed a lawsuit against the officer and the city of Tustin. Before the case could go to open trial, Villarreal's attorney argued before the judges for his qualified immunity.
But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired. He kept his hand in the front pocket of his hoodie sweatshirt. He moved from a place of relative safety on the shoulder of the road into the roadway. He was skipping
But if we're
backwards.
talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Well, I don't recall at what point his camera was turned on, but
his camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see.
The officer had instructed Mr. Herrera to take his hands out of his pocket. As he did that, he took less than a second to take out his weapon and shoot him twice. Later, it was also discovered that the suspect was unarmed and posed no threat to the officer.
What's on the videotape, and now this is an Officer Villarreal's car, I hear him say, take your hand out of your pocket, and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision. Before, he was asked in deposition, well, what were you going to do when you asked him to take his hand out of his pocket? Well, I was going to put him in a control position. That's what he intended to do.
So he's taking his hand out of his pocket.
Yes.
And as he's obeying the officer's command, he gets shot.
But it's the way that he does it, Your Honor. He didn't just stand still and take his hand calmly out of his pocket. As soon as he began to take his hand out of his pocket, he also moved quickly toward the front windshield, the front passenger window of Officer Villarreal's car.
Well, right.
He had a fraction of a second to make
Well, don't
that
we
decision.
have to view this in the light most favorable to the plaintiff here? I mean, and so if we do what you just said right now, offer two possibilities. He did it peaceably or he did it in reaction. And so I'm just struggling with, in light of the standard that we have, here, Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket.
The case seemed to be open and shut, where an officer had brutally murdered an innocent man who was only complying with his commands. To make matters worse, the attorney still fought for the officer's qualified immunity, which should be gone now.
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know, with the benefit of hindsight, obviously, that was wrong.
Is it significant that Miali?
Miali
didn't fire? Chose not to fire? I mean, it seems like he had a better vantage point possibly than Mr. Villarreal.
He actually didn't, for these reasons. First of all, well, I'll answer your question directly, and then I'd like to go back to the standard. Officer Miali was facing, from his point of view, he saw Mr. Herrera's back. not Mr. Herrera's front. So he couldn't see, and he testified in his deposition that he couldn't see Mr. Herrera's hands as they were coming out of his pocket.
I guess the issue I'm having here is that these are arguments, in my mind, for a jury. That certainly you can lay these out, but we're at a very limited scope here. This is not jury redo. We have to determine based on the facts as alleged by the plaintiff. And they're gonna say, no, it was, he simply had his hand in his pocket and these officers were coming up on him really strong. They created the tension. They rose the adrenaline, not him. You have to lay out, take their facts, not the facts as you want. You gotta stick with their facts and explain why under their facts, you win as a matter of law.
I agree, Your Honor.
And right now we're talking about your facts.
As long as...
Stick with theirs.
As long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury because we don't want juries second guessing the very, very difficult life and death decisions that officers have to make.
The attorney had the audacity to claim that it was a reasonable mistake. A young man had lost his life, whereas the officer was free without any accountability. It is bizarre how these police officers are often considered above the law.
Opinion at Espinosa clearly somewhat favor denial of qualified immunity under these circumstances. I don't know if you're familiar with Espinosa, but it seems to be.
I'm sorry, Your Honor, I don't believe that I'm familiar with the Espinosa decision.
In Espinosa, the suspect had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really pose any
I don't think
threat.
anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here, that's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here is raised about the fact he didn't have a gun.
I understand. The trial court did.
And that's not what we're doing right now. Again, this is not trial court part 2. This is a very limited inquiry what we have to do here.
I understand, Your Honor.
Shortly after, the plaintiff's attorney also took the stand and spoke to why the officer's qualified immunity should be removed.
Good afternoon, everyone. My name is Dale Gallipo, and I'm representing or speaking on behalf of the appellees and the plaintiffs in the underlying case. I think the comment made, a lot of the arguments we believe they're being made here are more appropriate for a jury. Because in this case, there are a host of undisputed facts that we actually think favor the finding of the district court judge. And there's other facts that I think are either disputed or they're entitled to different reasonable inferences. And as I think was pointed out, for this limited purpose of today's hearing, one has to take all the plaintiff's facts as true and all reasonable inferences in their favor.
Well, let's look at what's undisputed, because I think it's a really interesting question we have here. When we look at what's undisputed, Mr. Herrera, I think you could say suspiciously, kept his hand in his pocket, and that the officers perceived a heavy object in that pocket. That's...
First part, yes. Second part, a little less clear. But I think there's no question that he had his hand in his pocket.
Well, and both officers said it looked like he had something heavy in his pocket.
Okay.
All right. And then just before Mr. Vial opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons. He responded to a command. He was given a command. He has a hand in his pocket, and he was giving a command to show his hands or take his hand out of his pocket. The officer was asked, what was your intention? I wanted him to take his hand out of his pocket. he took one reasonable inference again is he took his hand out of his pocket in compliance with the command of the officer. When he took his hand out of his pocket, he had nothing in his hand. Another reasonable inference is that the officer could see that he had nothing in his hand before he fired his shots.
The attorney was also asked about how the officers are allowed to make a reasonable mistake, and he had a fantastic answer for this as well.
Opposing counsel that he's entitled to make a reasonable mistake.
Well, if that was the standard alone, then every single shooting case, the defense would argue that an officer is entitled to a reasonable mistake, and that's the end of the analysis. I think for purposes here, one has to look at the facts supporting the plaintiff's version and then decide whether one can say as a matter of law that the shooting is justified. Under our version, both hands were visible and he had nothing in his hands and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief, that deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available, and that a warning that deadly force, that his decision not to shoot when he saw the hand come out of the pocket with nothing in it, was a more appropriate decision.
After hearing the plaintiff attorney and the judge's remarks, the defense again decided to appear and try something to get the judge moving.
Mr. Gallipo will bring in his use of force expert to talk about what should have happened. I mean, juries do make determinations.
But they're not making determinations on qualified immunity, and that's the only issue in this appeal, qualified immunity, and whether or not the actions of Officer Villarreal were objectively reasonable in light of all of the circumstances.
You said something that confused me. The jury does not get to decide qualified immunity?
Qualified immunity is a question of law for the court.
You mean, so depending on, the jury has to decide whether or not there's been a constitutional violation, and at trial the jury cannot say to your officer, you're off the hook because you have qualified immunity? That can't be right.
It's my understanding that the application of qualified immunity is a question of law.
Well, it is a question of law on undisputed facts or facts taken in favor of the other side, but I've never understood it to be outside the province of the jury when it goes to trial.
Well,
to say that the officer does not have qualified immunity.
The jury has to decide the underlying predicate facts.
I understand that, but I think I'm arguing on your point. If we send this back, I don't think you want to say qualified immunity is no longer available to you at trial.
Absolutely not.
Well, I think that's what you just said. That's why I'm speaking up.
That was not my intention at all.
The video of this sad incident was not made public, and the judges ended the trial.
The videotape evidence, the deposition testimony that we have, shows that Mr. Herrera's actions, Officer Villarreal's actions, are not in dispute. We know what happened, and it's just a question of whether or not a reasonable police officer, knowing the same things that Officer Villarreal knew, would have felt justified in firing.
This is a question that's off to one side from the merits of the question we are now being asked to decide, so I want to make that clear. But I would like to know if you can answer this. If everything goes bad for your client, that is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless there were
punitives.
If there were punitive damages, the city would have the option of deciding whether to pay those punitives. My understanding is that
soon after this trial, the judges passed a written statement where they denied any qualified immunity and alleged that the officer had used deadly force against the victim. Moreover, the city settled with the victim's family for $1.4 million, and the corrupt officer was out of his job. Well, this brings us to the end of this video. Today, we explored cases where police officers were held accountable for their actions in court. These instances demonstrated that law enforcement officers are not above the law. When they cross the line and break the law, they face serious consequences and are swiftly held accountable in the courtroom. Now, if you agree with me, please consider showing your support by liking this video and also making sure to subscribe to stay informed about future cases like these. Also, if you enjoyed the video, check out the next video here.